Hello friends, this is Rajeshwari in series Constitution of India in the Right Perspective. Today I'll be discussing Supreme Court of India, Article 124 and other related articles. Supreme Court of India is the highest court of appeal, and it was established under the Constitution of India on 28th of January 1950. It replaced the federal court that was established in 1937 under the Government of India Act 1935. Supreme Court enjoys much wider powers than the federal court, and its seat is at Tilak Marg, New Delhi. Its present strength is 33 plus 1. Chief Justice of India Mr. S.A. Bobde and 33 other respected judges. And so far as the appointment of the judges to the Supreme Court is concerned, Article 124 Clause 2 says that the Supreme Court judges shall be appointed by the President of India by a warrant under his hand and seal, and the appointment after appointment it is published in the official gazette, and then it takes the legal form. Then we come to clause 3, article 124. It speaks about the qualifications. Qualifications are that firstly he must be a citizen of India, and secondly he must have held the office of the judge of a high court or two or more such courts in succession, or he must have practiced in the high court for 10 years or more, or in the opinion of the President of India he should be a distinguished jurist. So these are the qualifications, and as far as the removal is concerned, the proviso to Article 124, it says that a judge may himself resign by writing under his hand, addressed to the President of India, or he may be removed by a process of impeachment as provided in Article 124 Clause 4. Now, to ensure the integrity and independence of judiciary, certain provisions are incorporated in the Constitution of India. One is Article 124 Clause 7, which says that after retirement, no judge of a Supreme Court shall act or plead in any court or authority within the territory of India. Then there is Article 121, which says that no discussion would be made in Parliament on the conduct of the judges of the Superior Court in discharge of their duties. Then Article 125, which says that the privileges and the rights and allowances of the judges of the Supreme Court shall not be varied to the disadvantage of a judge after his appointment. Then there is Article 129, which says that Supreme Court is a court of record with power to punish for its contempt. Then the salaries and pension of the judges of the Supreme Court, they are to be charged on the Consolidated Fund of India. And then there is Article 124(4). The removal of a judge is through a very difficult process of impeachment. It is just similar to same as is for the President of India, and then its tenure is fixed at the age of 65 years. He retires. So these are certain provisions that make that ensure that judiciary acts independently and with integrity also. Now we come to the appointment. Before entering upon office, judges to take oath, as is provided, the form is provided in the 3rd schedule to the Constitution of India. And Article 124 Clause 2 the appointment of judges. Now, President makes the appointment, but the original clause to it said that President shall make appointment after consultation with such other judges of the Supreme Court and the High Court which he deems necessary, and this accepting where Chief Justice himself is to be appointed, CJI would always be consulted. Now, this process continued till 1981, when a batch of petitions were filed before the Supreme Court challenging the appointment of certain additional judges or non-appointment of some judges, and there were certain other issues also. And then the main issue was what is the scope of consultation with CJI in the matter of appointment of the judges. Now, these petitions were disposed of with two main findings, two main. One was that so far as consultation is concerned, that was the case of the appointment of the High Court judges. That was under Article 217. 217 says that appointment shall be made by the President after consultation with the Chief Justice of India, Governor of the concerned state, and the Chief Justice of the High Court concerned. So, what the Supreme Court laid in that case was that primacy cannot be given to any one authority, to the Chief Justice of India or to any other authority, because President consults all the three, and for varied reasons, and each authority, the opinion of each authority is equally important. So primacy cannot be given to any one authority. And secondly, that is very important, certain conversations between because that issue was non-appointment of some two judges, and the conversation between the Chief Justice of India and the Minister of Law and Justice and the Chief Justice of the Delhi High Court, it was prayed that those conversations be made public, they be made available to the petitioners. Now, the Government of India contended that because it is on the advice of the Council of Ministers under Article 74 that the President of India, President makes the appointment, that advice that is tendered by the Council of Ministers to the President is protected, that is not to be disclosed. So the conversation between the three authorities was part of, it made a substance of what advice was tendered to the President, so that is protected. But the Supreme Court held no doubt the advice under Article 74 is protected, and the conversation between the three authorities that was part of the advice that was tendered, but that the conversation that is not protected, because it is right of people to know. At that time, in 1981, there was no Right to Information Act, but even at that time, Supreme Court held that right to information is implied in Article 19, Clause 1A of the Constitution of India, and to have a participatory democracy and to have a more accountable democracy, it is necessary that people are provided the information regarding the functioning of the government, and unless it is very necessary, it is in public interest not to disclose the information, it must be disclosed. So this is very important observation of that judgment that was overruled later by a case that was, we call it the Collegium case, because there are three judges cases that shaped the appointment of the judges to the Supreme Court, the Collegium system. So first is the S.P. Gupta case, then we come to the second Second is a petition was filed by Advocates on Record Association. It is Supreme Court Association of Lawyers who clear some examination that is held. So they filed a petition, and there are two main issues were to be decided. One was what is scope of consultation. It is in Article 124, Clause 2, it says, after consultation with Chief Justice of India and the other judges. So what is the scope of consultation? Does consultation mean concurrence? So this was not accepted. This argument was not accepted in S.P. Gupta case because certain debates, the parliamentary debates at the time of adoption of this article, they were referred to, and the Dr. Ambedkar and other members of the Constituent Assembly, they had said that President is the final appointing authority, and he is not bound by the advice. He will seek advice from all the authorities. If he fails to seek advice, that is an irregularity that can be challenged, but he is not bound by the advice. Now here, this issue again came up for discussion before the court. Second was the fixation of the strength of the Supreme Court. Now in this case, Supreme Court held that the Supreme Court, the Chief Justice, he should have the primacy. So it says that the primacy in the appointment of the judges to the Supreme Court should be with the Supreme Court. So what they did is that they constituted a collegium. It consists of the Chief Justice of India, and firstly there were two other judges, then four other senior most judges of the Supreme Court. They constitute a collegium. Similarly, there is a collegium for High Court. So Supreme Court collegium, it does not appoint, because appointing authority is the President of India, but it selects and it recommends the names of the judges for appointment to the Supreme Court and the High Courts of the country. And the High Court collegium, it recommends the names for the subordinate judiciary. Now how this collegium works is that it would recommend the names. The Government of India has been it has been reduced to a very limited role of getting the security clearance from the Intelligence Bureau or any other authority, and the Government of India may seek some clarifications or may make some suggestions or some recommendations which Chief Justice of India may ignore. And if the Chief Justice of India again reiterates the same names, then the Government of India is to accept. It is to accept the recommendation. It's legally bound to accept the recommendation, and they are to refer the name to the President of India to make the appointment. Now we know that in 2014 an amendment of the Constitution was brought about, and Article 124 A, B, C were inserted into the Constitution, and that spoke of establishment of NJAC, National Judicial Appointments Commission, and this commission was constituted by the Chief Justice of India, two other senior judges, and then two eminent persons were to be appointed by Prime Minister, Minister of Law, and Leader of Opposition. But this NJAC was challenged in the court, and the Supreme Court struck it down, being unconstitutional, that impact the independence of judiciary, because executive will have a greater say, greater role in the appointment of the judges. Now coming back to the collegium system. Now when we see what is the impact of the collegium system, this system worked initially, but later there were allegations that it was not functioning, it was not that desired result that was expected was not coming, and there were allegations that the sons and daughters and the wards, close relatives of the judges, were being appointed to the higher judiciary. So this was challenged. Recently also there was some national the lawyers' campaign for judicial accountability, transparency and reforms, and they also filed a petition that the judgment of the advocates on record that set up the collegium system, it should be reviewed, and court dismissed it on the grounds that it was too late by more than 9,000 days, so that it is not explained, the delay is not explained, so it was dismissed. Now when we look at let us examine this collegium judgment. What it did is, earlier it was the President of India who would recommend the names to the Chief Justice and other judges, whomsoever he wanted to consult, and CJI and the judges would submit their opinion, their advice, and final authority was President of India. Now what the situation is that Chief Justice of India in Collegium, he recommends names to the President of India, and he returns again. If CJI reiterates the same names, it is legally bound on the President of India to accept the recommendation. Now what is this? Firstly, can CJI direct the President of India, who is the appointing authority of Chief Justice of India and other judges? Firstly. Secondly, when you make it mandatory, compulsory on the President of India to accept the advice or recommendation of the President of Chief Justice of India, it amounts to amending the Constitution of India, Article 124, Clause 2. Clause 2 nowhere says that President of India can be compelled by Chief Justice. This happened when Article 74 was amended, when Prime Minister in Council wanted President to accept his advice. Mandatorily, the Constitution, Article 74, was to be amended by virtue of 42nd Amendment that I have discussed in my previous video. So here, Supreme Court amended the Constitution without actually having the amending powers. The power to amend the Constitution rests with the Parliament of India under Article 368 of the Constitution of India. Now, why this was ignored by Parliament, I have no idea. But does this act of constituting a collegium, which makes it mandatory on the President to accept the recommendation of CJI, is it not ultra-vires the Constitution? This is an issue for debate. Secondly, was this collegium constituted with no mandatory clause? The final say, if was left with the President, it would have been legal, because under Article 141 and 142 of the Constitution of India, Supreme Court has the power, law-making power. 141 is that the law declared by Supreme Court is to be enforced throughout the territory of India. It is the law of precedent. 142 is in deciding a matter before it. Supreme Court can make any orders or pass any decrees that are necessary to do complete justice in a matter. The Vishakha guidelines, if you have heard of, they were laid under these two articles. Now, if under those articles collegium system can be constituted, but if you make it mandatory, then it is ultravires the constitution, it is unconstitutional, it amounts to amending the constitution, the power that is not at all vested in the Supreme Court. Now let us presume that all the exercise is constitutional, is within the powers of the Supreme Court. Now we come to the collegium system. Why is this being challenged? Is it working in accordance with the principles of democracy? Is it working? Is it in conformity with the basic structure of the Constitution of India? What happens? Collegium sits, and after that a recommendation comes out. There is no transparency, first of all. What transpires in the collegium, which respected judge made what comments. Right to information requires the minutes are to be recorded and they are to be made public. Secondly, there is no rule laid down. Every judge of a high court or an advocate who aspires to rise to these offices, he should know whether he is capable, what is the eligibility criteria, what are the other criteria on the basis of which a person, an advocate or a judge is to be selected. There is nothing on that. Thirdly, the law requires that the powers that are exercised by the authorities, they are in conformity with rule of law. Now what rule of law says is, now this is reiterated by Honorable Supreme Court in the Advocates on Record or the Collegium judgment, that discretionary powers are necessary. No doubt they are necessary. No government can function, no institution can function without discretionary powers. But discretionary. And a discretionary power is when some rule, some policy is laid down and in accordance within the precincts of, within the four walls of that, those policies or the rules, the authority functions. And if there is no rule, there is no policy, there is no such guideline, the discretionary power becomes arbitrary. And arbitrary power is anathema to democracy, Supreme Court says. And if you read the re in re, the natural resources, in re term is in the legal case of. Supreme Court has very discussed this issue of arbitrary and discretionary, and says the question of unfettered discretion does not arise. So what is grievance of those who are challenging the collegium system? It is transparency, it is policy, it is rules, guidelines that are laid down, and everything, it should be predictable. It is in re natural resources, it is said that the action of the authority, it should be predictable. Person should know whether I am eligible, I will be there, I won't be there. So this is an, if you remember, there was a revolt by 4 respected judges. What was the grievance? Grievance was not that why Chief Justice has the power. The Chief Justice is the master of the roster, and he can allocate the cases. But the grievance was that there was no rule. There was no rule, There was no policy. If there is rule, every judge would know which case would go to which judge. And in that the press conference also, another issue raised was that no memorandum of procedure has been finalized. That was the requirement in the Collegium judgment with regard to appointment, with regard to functioning of the Collegium. Memorandum of procedure was to be laid down, and nothing of the sort has happened. So, in the light of all this, what we conclude is that may it be Collegium or may it be the earlier or NJAC, whatever, the thing is they must function in accordance with the principles of democracy. In SP Gupta also, court said this information is to be made available to public. And in many of the Supreme Court judgments, there has to be transparency, there has to be rule, action should be predictable. So if in accordance with that, the Collegium works, I don't think anybody would challenge the Collegium system. Then there is another clause. We would go to Article 124, clause 4, that is the removal of the judge of Supreme Court. Now the removal is through the process of impeachment by an address that is in both the houses of the Parliament, and that motion is to be approved by majority of total strength of the House and by a majority of 2/3 members of the House present and voting. So if it is approved, then the judge would be impeached, he would be removed, and the grounds are the proved misbehavior or incapacity. For that also procedure is to be laid, and that is under Judges Inquiries Act 1968. And second point is that in the same session when this motion is approved for removal of judge, in the same session it is to be presented before the President for removal of the judge. If it is not presented, then it would lapse. But that does not mean that if the motion was accepted, the proceedings started in the earlier session or in the previous Parliament, the motion would lapse. It would not. And that was laid by Supreme Court in the case of Ramaswamy, Sarojini Ramaswamy's. She was in the case of, because Justice Ramaswamy is the only judge of the Supreme Court who faced the impeachment proceedings, and though proceedings started, but because the ruling party abstained from the voting, so they could not get the required vote, so he served the rest of his term. The other judges who faced as Justice Sumitra Sen of the Calcutta High Court, and Justice P.D. Dinakaran, Sikkim High Court, Justice S.K. Ganguly of the Madhya Pradesh High Court, Justice J.B. Pardiwala of the Gujarat High Court, they also faced the impeachment proceedings, but Justice Sumitra Sen and Justice Dinakaran, they resigned before it could be they could be impeached, and against Justice Ganguly the charges were not proved, and Justice Pardiwala also, he removed the offending remarks from his judgment against reservation, so there was no motion was not taken up, and so this is about Article 124. And in the concluding remark, I would just say that as Supreme Court says that courts are the conscience of the Constitution of India, and if anything goes wrong, conscience speaks. So I just would request, if there is something wrong with the Collegium system, people are raising doubts, then the corrective measures should come from within the judiciary, and that is the best thing to happen. Thank you.